So, first of all, welcome to this workshop on EU environmental law. What will we do during this workshop? Basically, there will be three main parts, divided in the first part, in which we will explain a little bit the basics of EU law and how to read a directive. For the exercises that will come afterwards. You will indeed make an exercise and in order to understand and interpret a directive as well as a case of the European Court of Justice. We think that these exercises will be divided one after the first presentation and one after the second. That will be focused more on the application of EU law, and so on the interpretation of EU law by the courts, national and EU courts. So, part one. So the EU law. In order to understand EU environmental law, we thought it was necessary to know a little bit about EU law more generally, how it works, because EU environmental law is a part of the system of EU law, and thus it works as many other sectors of EU law. So EU environmental law, as many other sectors, it's based on the Treaty of the European Union and the Treaty on the Functions of the European Union. After the Lisbon reform, the basics, the structures, the two pillars of EU law are these treaties. You can understand them as the constitution of the EU. While the Treaty on the European Union is more focused on the objectives and the principle of the EU, the Treaty on the Functions of the European Union is a little bit more technical, and it's a focus on the organizational and functional details. These two pillars form the primary law. So whatever you will come to analyze, a directive or a regulation, a decision, whatever, will be based on these two pillars, and which are also the basis for seeing if a directive or a regulation is can be actually applicable. So, which is one of the questions that's come, and it is very much very well explained in the treaties, is the relationship between EU and national law. What is interesting about EU, you have to understand it's because EU usually we see it as in between international law and national law. Actually, it has a quite unique structure, because member states or states that sign and actively decide to take part to the European Union actually decide to confer the European Union some powers, to legislate, and so actually to renounce to some of them in order for the EU to take them. It's a quite unique form, unique organization in the world, and so the way in which the member states and EU interact is based on the principle of conferral, the principle of subsidiarity, and the principle of proportionality. So since the member states have decided actively to take part of the European Union, they have decided to confer it some of the powers that they had before, as I said in the beginning. But the European Union is strongly bound by the principle of subsidiarity and proportionality. The principle of proportionality, among the others, regulates in order for the EU not to take too much power in order and not to overcome over the powers that remain with the member states. However, we can also see that the power of the European Union, so the strong structure, is also based on case law. So the European Union is also takes as principles the principle of supremacy and the principle of direct effect, which were decided by two very important cases, which are Costa versus Enel and Van Gendel loss, which actually they express that the European union law has direct effect not on the individuals and the private individuals of the member states, and that whenever there is a national law and European law regulating on the same matter, European law prevails. This slide was more or less to make you understand the hierarchy among EU and national law, which is not black or white, is much more, there are many shadows, but in simple words, this is a little bit the structure. Sorry. Okay. The EU, we have said that they regulate. The EU regulates on many matters, which are many matters that always are explained in the treaties. It can have exclusive competence. It means that the member states decide that the European Union has, only the European Union has exclusive competence to regulate on certain matters. Shared competencies, it means to regulate with the member states, and supportive competence. It means that the European Union helps to member states which have actually the majority of the power on those matters. Into brackets, environmental and energy matters are always shared competence. So the EU regulates with the member states. The key tools of EU law, which are also called secondary law, always based on primary law, so the treaties, are directive, regulations, and decisions. These instruments are a little bit different with each other, so we will see them now. Directives are pieces of legislation that are entirely binding, indirectly applicable. It means that they are binding in their entirety of their form, and they are indirectly applicable. It means that member states, have to transpose through a national act that directive that has been signed and adopted. It means that the European Union cannot give that piece of legislation the power to enter directly, suddenly into force, which is the case for the regulations, which are also entirely binding and directly applicable. One of the reasons why, indeed, in environmental law, we don't see many regulations, and it's quite more a recent trend, and still we don't see many of them. It's because indeed it's a shared competence, and member states still want to have control on what passes as law, and so directives are always like the most chosen. And there are decisions, but we don't see them now. They are directly applicable to. They are particularly addressed to particular subjects. So an example. Now we will go into, in order for you to read and interpret a directive as an exercise in the following minutes, we will understand a little bit how is the structure of a directive, because usually when you see it, it may seem all quite homogeneous in shape. Actually, it's very different, and the parts are very different from each other. So we've chosen the Habitats Directive, which is one of the two pillars of EU conservation law, with the Birds Directive, and it actually regulates and gave rise to a high number of cases that actually show that EU law on this matter actually had quite a success in the conservation status of species and habitats. So you will analyze later a case based on this. Basically, when you see a directive, what you see? The first thing is the preamble. The preamble is made of citations and recitals. So when you see the preamble, you will see, first of all, the legal basis where the directive is based off, otherwise it cannot be adopted at all, and the preparatory acts, so all the consultant bodies, the recommendation that, and the preparatory work behind. And then there are the recitals, which are the reasons behind the adoption of the directive, which in the case of the Habitats Directive is that they explicitly say that transboundary threats to biodiversity require a common EU approach, in order to be dismantled. Then we have the definitions. Usually you will see the definition, which are in this case in Article 1. All the terms that will come across during the directive are explained in the regulation, in the directive itself, in the definitions. So when you see the definitions, you read carefully to them, and then you will not have any question regarding some weird maybe a term you will come across. Then there are the objectives. So which are the objectives of the Habitats Directive? Well, to conserve biodiversity, maintain and restore biodiversity, while always, because member states are different and the habitats of member states are different, they have local, taking into consideration local differences and requirements. So we have the objectives, and in this case, Article 2. Then there are the measures. The measures, so the part that maybe the most technical part. In this case, you will find in the mentioned articles. I will not go into detail on this. Then there is the monitoring. So, like with the most procedural requirements. So, member states in this case are required to report every 6 years about the progress made with the implementation of the directive. We finally find the annexes, which in this directive I really suggest you to pay attention, because all the species that are protected in the directive are not explained during the previous articles, because there are many, like there are hundreds. So there are these annexes, which explain all the network habitat types of community interest, whose conservation requires the designation of areas of conservation, and same for animal and plant species, and so on. So the annexes are like a list of all the protected species in this case, and you will find yourself later during the exercise. A directive is usually follows these guidelines. There might be directive with more objectives. There might be directive with more with less definitions, but the structure of it usually is like this, with the following exceptions, of course. So later you will have time also to make here and write here some of the questions of the that you might have on the content. But for now, let's start with the exercise. Okay, Agnes, if you want to explain the exercise, will be here.
Thank you, Emma, for this presentation. I hope you got an idea of what is like the basic stuff about EU law, and now we're going to see how we can use these EU tools in a real life scenario. So thank you all for participating on this exercise. I wanted to ask, we have 5 minutes. Does anyone want to share their thoughts or what from different groups, what were the answers that they found or how was the process? Just sorry, I was muted. Open your microphone or share in the chat. And also you can raise your hand, whatever you want. Yes, you can go.
Yeah, it was definitely an experience having to jump around the document and people looking at different sections and then having to figure out what everyone is talking about, and then being able to piece together exactly what's in the text and then exactly how that can or should be applied. And it's a new process for me, so definitely a challenge. But when you know these directives and decisions and such inside out, then it can be a lot easier to just pinpoint exactly what's a problem and how to resolve it if there is a resolution.
Thank you for the reflection. It's Creonton?
Very close, Creven, like Stephen.
Okay. Thank you so much. Do we have anyone else that would like to share their experience or maybe an answer to some of the questions, what their group found? Okay, I can see some silence. So I can give you some hints because I don't like when people ask me questions that I don't get back answers. So does the habitat directive apply in this scenario and why? Here we could think about the overall objective and the goal of the habitats directive, which is, as it's written in the slides, to protect natural habitats and species of wild fauna and flora. And as I saw in some groups, they were searching if the wolves are included, and they are. It's correctly in the annexes in the end. But also we could focus here on the Article 12, which requires member states to establish a system of strict protection for animal and plant species. So that was the answer. And if this plan could align with the directive, primarily we would say no, because how wolf killing would comply with this directive that it's protecting the species. But under specific and limited circumstances, this is allowed, and it's written in Article 16, which allows some derogations from that strict protection, but only under strictly supervised conditions on a selective basis and then limited extent. So the basic articles that you should focus, it's in the beginning, which is the overall objective of the directive, and then it was like the 12th and 16th, which is the limitation, and then there's like a small window that you could have some derogations from the limitation. So that is the answer. And now we will continue with the presentation, and Emma can take the floor. Here you can find, all the answers from the groups. And I hope you enjoyed the conversation with your colleagues.
So thanks, Agnes, and thanks all of you. I think you all more or less understood what the point was. Maybe the difficulty is to find it in the directive, and we wanted to maybe introduce you to the exercise that actually is the main difficulty. Now we have seen a main instrument of legislation of the European Union. Let's go into the cases. Another very important, very difficult thing in law is to read a case. Let's first of all, as before, talk about the theory. So, what do you think is the role of the national and EU courts? Do you have an idea of what is the role of the courts at national and EU level for what concerns EU law? Well, we might think that EU courts apply EU law, right? And national courts apply national law. Apparently, all of this, both national courts and the European Court of Justice have a role. According, indeed, to the principle of effective judicial protection, national courts have a key role in applying EU law at member states level. Indeed, they have the role to control the application, apply EU law, and also constantly control that EU law is not breached. They also have the role to ask for preliminary references when European law is not clear. So for them, so to interact with the European Court of Justice and ask for clarifications. When national courts have this role, at European level, there is the EU Court of Justice, which is composed of the General Court and the Court of Justice. So the Court of Justice is a common name to call the judicial system, but actually is composed of the General Court and the Court of Justice, which deal, both of them, with preliminary references, direct proceedings, and appeals. So what are these? Preliminary references, according to Article 267 TFU, is when national courts ask for clarification on new law on a case to the EU Court of Justice. Sorry, something happened with the screen. Okay. They also can ask for answers to the national courts can ask for answers to the Court of Justice, and with the main objectives, preliminary references have the main objective to help national courts in order to ensure full and uniform application of the law. For what concerns direct proceedings, when member states breaches EU law, we call it direct proceeding. Or for example, when an EU institution act is challenged, we go with direct proceedings, which are commonly seen as like the cases in per se are called direct proceedings. And then we have the appeals. So when a judgment is asked by the subject to be reviewed, and it's the Court of Justice that is in charge of reviewing judgments that maybe before were adjudged by the General Court. These are the three main cases that we might find, and usually when you read a case, you directly understand whether it is of preliminary references, it's a direct proceedings, or it's like a case of appeal, a judgment. How do you approach a judgment from the European Court of Justice? A judgment of the European Court of Justice is usually follows also as this, I would say, template, this composition. So first of all, you will find the keywords that are necessary to understand the whole procedure, the whole judgment. Then you will see the all parties. So so-called the European Court of Justice, the European Union from the one hand, usually, and member states from the other. This is much more common. Or then there is the legal context, so the EU and national law. The problem that has come to be judged, the questions made by the national courts, discussion on the questions, and then a summary of the answers by the end, which always are in bold. So you will see, because they are at the end, they are in bold. So let's okay. Okay, so we came with this very brief explanation to the second exercise.